Any mention? Any mention? Item number 1.
Please, Your Lordship. Your Lordship, I beg to mention on behalf of Mr. Senior Advocate MZ Ahmed, Your Lordship. He's not well. He's not.
Is he here in this matter?
Yes, Your Lordship.
Huh?
Coal India.
On behalf of Coal India.
Coal India, Your Lordship.
On behalf of Coal India.
The coal was the custody of coal in an auction. Already auction, correct?
In this matter, it was not, Lordship.
Yes?
In this matter, it was not. It never reached because there was a stay order passed by this court.
No, Your Lordship, it was already auctioned.
PIL auction ke baare mein kuch PIL has nothing to do with the auction part, Lordship. PIL, Lordship, in very short, is a grievance is that, my Lord, the respondent 14, by using e-way bills, not having any document to show the actual origin of the coal, has exported rather about 1.75 lakh metric ton.
Not only thing is that to show the origin, correct?
Lordship, yes.
That's what he showed.
Lordship, yes.
Where the origin from?
Lordship, yes. Now, there was an order passed by this Honorable Court, Lordship, way back in 2023.
Which order is that?
If I may take a Lordship, this order. Lordship, this is of 11/4/2023.
Yes. What does it say?
Lordship, if I may just read the relevant part, Lordship. Right. Lordship, essentially it says that, my Lord, that the...
No, which part are you reading?
Lordship, is open the order 11/4/23. Lordship, may kindly give me 1 minute, Lordship. Lordship, there's a paragraph in between. Lordship, it will be open to the respondent. It begins with, it will be open to the respondent number 14. Page?
Internal page what?
Lordship's internal page, I am not able to. Because this is in my page 975 of my rejoinder, Lordship. Towards the end of the order, Lordship.
Page 9.
And internal page, I did not have it.
You'll be able to file a further affidavit.
Lordship, it says,
it will be page 9, my Lord. Page 9. It will be.
I'm great.
Yes.
It will be open to the respondent 14 to file a further affidavit, if necessary, to indicate the source of the vast quantities of coal as noticed in the order dated so and so. It would not do for the respondent number 14 to merely cite another trader from which the coal was obtained, since the large amount of coal then in the possession of the respondent 14 so and so would have come from some specific mines, and it is such mines or the source of coal which ought to be indicated. It is my humble submission, my Lord, that till date there is no document. He has repeatedly filed e-way bills and challans in the name of other traders. In the meantime, what had happened is, Lordship, an affidavit was filed by the respondent 14 saying that he has procured the coal from Beltola, open market in Beltola. Pursuant to the directions of this Honorable Court, my Lord, the Assam State Police, under the supervision of the SP and the DGP, had gone for an inspection or an inquiry, and they have also filed an affidavit in this matter itself, saying that it is not possible to purchase any coal from the open market in Beltola, let alone such large amount.
What is the quantity?
About 1,75,000 metric tons, Lordship, exported. Lordship, the 1,74,725 metric tons, which he has exported, Lordship, in a span of about 6 months.
It's already exported, or it was seized?
No, this was exported, Lordship.
There was a quantity of seized also.
16,000 metric tons.
Seized is 16,000.
That's small amount.
16,000
subsequent.
And a FIR has been registered and the case is pending.
So what are we to do today then?
My Lord, my humble submission is that till date, my Lord, he has...
Yeah, that we are aware.
Yes.
Because he has been 2 years, that we are aware that that was the outstanding query.
Yes, because more than that, my Lord, at this stage, the petitioner has no further submission, because this was the very initial grievance, and till date, my Lord, there is nothing to counter that allegation, Lordship.
Yes.
My Lordship, my humble request is, as he is highlighting a order dated 11/4/2024, he is concealing the affidavit dated 25/4/2023, filed by me, 25th of April 2023, right after that order, my Lordship, wherein even in their compilation report, what they are projecting in their compilation report has nothing to do with it. They are only beating around the bush, my Lordship, when they say that their invoices are fake and things like that. In that affidavit dated 25/4/2023, my Lordship, I have annexed all the GST invoices which have been processed on the GST portal itself.
It is there in the compilation also, Lordship. All the pleadings are put in the
Where
compilation.
the compilation? Even the affidavit is there.
Lordship.
Yes, my Lordship, affidavit is there, but the summary which they have given on the outside page.
That summary will.
Yes, my Lordship.
Page 612 of part 2, Lordship. This is the affidavit which my friend is referring to. Part 2, page 612.
Another volume.
Part 2, Lordship. A list of pleadings, part 2. Page 612.
In that particular affidavit, my Lordship, the annexures which I have annexed from that portal, GST portal itself, all the invoices which we gave to the court were processed on the GST portal itself, and till date, even the GST department from Guwahati, there is nothing other than allegation. The only point which we said earlier was that the state of Assam was vindictive, and we have also given the proof. Like my learned friend is saying that as there was no coal available in Assam, that was the report which the Assam government gave. But there are documents to show that during the same time and during the same period in which we traded the coal, there were quantity of more than 9 lakh metric tons which I could access. The official documents from the Assam government. So their claim, the claim of the Assam government stating that there was no coal available for them to trade at during 2022 during our period is officially proved, my Lordship. And thereafter there has been no submission from the Assam government side regarding whatever on affidavit I have put forth on affidavit dated 28/4/2023, my Lordship.
25.
25, sorry. And
This page annexure 2 is a photograph we annex.
yes, my Lordship, not only photograph, my Lordship.
And your GST annexure 3 is this GST invoices.
Yes, my Lordship, they have been processed, and all the invoices have been validated by the GST department itself from where the allegation have started, my Lordship. And as rightly said by me, my Lordship,
Yes.
this court has been misguided time and again, not only by the petitioner but by certain other influential persons for their personal interest. So that's why, my Lordship, I filed an affidavit dated 12/3/2025.
25.
Yeah, 25. 12/3/2025, sir.
If Lordship would please to see page 643 of that in continuation, Lordship.
Yes, my Lordship. In against that affidavit,
643,
643.
part 2.
Yes.
Lordship, as kindly see this. This is a letter 16/5/23 after he has filed this affidavit.
Yes.
This is, my lord, to the senior government advocate of Assam, such and such. With reference to the above and in response to the order passed by the Honorable High Court of Meghalaya, a team of so and so EOs from the Economic Offences Wing under the leadership of Inspector so and so sent for wheel verification, submitted the report. Kindly see the report, my lord, at the next page. Addressed to the SP of Assam, my lord. Lordship, if I may read 5 lines from the bottom, Lordship. Hence, possibility of dealing of huge quantity of coal was not feasible on the part of any coal dealer located in Beltola area.
But how are we to verify this? How are we to, sitting here,
What I'm
how are we to understand whether on one hand he says he has GST invoices showing that he picked up the whole open market, paid GST and it's been shipped.
Lordship, even
and
if he has...
It's a GST authorities are silent. Now from this police, whatever investigation, Now he says that's not possible. So who are we to believe?
Lordship, my only humble submission is this, Lordship,
Yes.
that even if he purchases coal from the open market or from any market, when the major mineral is mined from a source, my lord, a document of origin is always
No,
there.
we understand that.
Lordship.
Only thing is that suppose document of origin, suppose you're a coal trader, correct? You will not, when you pick up from a depot, as was the practice before,
Lordship.
just pick it up from a depot. You have some supply order you have to satisfy in Haryana somewhere. So what happens in Biltola is a hub, and so they pick up coal. I don't think they would be alive as to which mine it came. It's not GI tagged, anything that matters.
Lordship is, but
So
in
how do traders ascertain whether the coal is illegal or legal, or
Lordship,
is there a mechanism?
what the government of Assam says is that it is not a question of how much quantity he has bought.
See, what the letter says is that during the field verification, it was not possible
for
that
anyone.
anyone could trade in such a huge quantity of
Lordship,
coal. Fine. Now that raises a question. That means it's come from somewhere else.
Lordship, yes.
It has not been bought from the
Open market.
market at all.
Lordship, yes.
So, and sitting here now is this, and then we have GST invoices. He says that that show
And
that this
these-
coal GST has been paid on the coal, and so how are we to
Lordship, because
balance all this?
These GST invoices, as recorded in the subsequent orders, what has happened is there is a circular trading.
My,
GST invoices, my lord, are what he is trying to show is that he has bought it from one of his own sister company, got an invoice, and using the name of another third sister company, he sold it to another company. And now, in the name of this respondent 14, he is exporting the coal. So he has created that fictitious chain of supply.
my
But
lordship,
what is the fact is, my lord, I again, for the sake of reiteration, my lord, is that he is talking about GST, invoice, hundreds of things, lordship. Let him show a single document to show 1 metric ton of coal has been obtained from such and such mine, lordship. He has exported about 1.75 lakhs.
No, that we understand. We're not going to let him go that easy. The thing is that there is a very still outstanding that where did the coal come from?
Lordship, yes. Because he cannot simply say that, see, I have the GST invoice, so I don't know where the coal has come
So
from.
look at GST invoice to see
my
it come
lordship.
from. It's his name. Then Balwan Bhama, Sachin Kumar.
These are all his. There is also a firm called my lord, Vaishno Devi Traders.
No, we are
And
aware
all
what
that,
that is.
lordship.
my lordship, like there are a number of facts on which my learned friend have once we have filed the affidavits, rejoinder affidavits, to align with the aim of this court to go beyond what they have been alleging, my lordship. And last 3 affidavits only, I think they can summarize it very well, like the affidavit which we filed and the rejoinder which they the reply to our affidavit on the allegations which they have made, and they have tried, and the rejoinder in which we clearly proved that they have been the instrumental in misguiding this court on every aspect. Even now, for the sake of this thing, they are making Assam government has alleged that no coal was available. They are not highlighting the affidavits which we did file after that survey was done. He is only reading out the line. I have given the audio in script of those persons from whom they have only given the statements, my lordship.
Yes.
They asked the wrong question to the people. They went to the people, Assam government, because they were vindictive against me, and they asked them that will we get Meghalaya coal? Will we get Meghalaya coal? They were asking for Meghalaya coal to the people, and I have that audio clipping which I have even given them a copy. They are not highlighting that copy. What the statement was taken by was from a single side. Only Assam government was party to that survey. Had it been a survey of a joint survey where Meghalaya government or maybe we as a private respondent would have participated, it was very clear from our documents and from the documents we procured from the Assam government that 9 lakh metric tons of coal was traded during that same period.
That is what. See, we're sitting here in PIL jurisdiction, but then how are we to ascertain exactly your submission against it? Yes, Mr. Arjun, what?
Yes, my lord, the issue what I understand.
Because the issue is still alive.
Yes,
the
my
thing is that it's stuck between.
Yes, my lord. My submission is, my lord, the PIL petitioner is saying that the respondent number 14 has illegally transported 1,75,000 metric ton of coal, for which certain reports have been submitted by the Assam Police, my lord, saying that it has not been done. Petitioner is disputing the report of Assam Police, my lord. That is the issue. Now, this issue cannot be gone into in the PIL where fact finding can be. If the PIL petitioner has some grievance, etc., Justice Kataki committee is there entire matter can be referred and examined, because there has to be fact
But it's
finding.
too far down the road.
So now the 1,75,000
document, Lordship, the PIL can be disposed
My
of.
lord,
I'm waiting
because
since 2 years. Lordship.
because the problem is that as on today there are two conflicting versions before your lordship. One by the petitioner.
No, we understand. I think the query that was put from that order 11/4/23
Yes.
remains unanswered
Lordship,
as
yes.
to where did the code originate from.
Yes, my
Now,
lord.
on one hand, suppose if
So then the court will be required to go into the fact finding issue, whether the origination is from outside their source Belatola, or from Meghalaya, or Nagaland, or which. So therefore it will require some kind of fact finding approach, my lord, because both the affidavits are I am unable to come
we
to
are
the
unable to
yes.
navigate through all this.
All these,
it will
yes, my
become
lord.
like a
Yes, my lord.
my lordship,
It's not required also, my lord.
my lordship, 80 effective hearings have taken place regarding this matter, and every time they are beating around the bush regarding the same issue again and again. Once it was very clear when the Assam government said that we were running a fictitious business, my lordship, they seized my 4,000 metric ton of coal in Assam. Okay, and they did not inform even the court. I have that on judicial orders, whereby the conduct of the Assam police, we have proved that they are vindictive, and they also
But
it
are they
was
party here,
political.
Assam
Yes,
police?
They are party, my lord.
they were a
represented
party,
at one
and
occasion.
once we
They had appeared earlier.
my
when
lordship,
these
earlier
reports
they
were filed.
appeared once the reports were filed, and once we filed our reply to those reports, and once it was very clear that okay, this whatever survey they have done, once I got those clips from those same people from whom the Assam police said that they have taken the statement, and purposely they filed the statements in SMEs, my lordship, so that this court might not be able to get the entire version of it, and no translation was also filed. So I went
That is
through.
not a problem, but the thing is that where are we going to go with this matter? That's the only thing. We
My
can't
lordship-
just keep it hanging. Like you say, 80 hearings also.
80 years, yes, my lordship, and last three affidavits, my lordship, whatever, my last affidavit which was filed on 12/3/2025 has not been answered by them also, my lordship. And again, like on the name of the rejoinder, they are again filing the summary of the entire case in their own version, my lordship.
12/3/25 last affidavit.
Yes, my lordship. They filed a reply to that affidavit on 26/5/2025, my lordship, and to that I filed a rejoinder on 22nd of August 2025, my lordship. Last three affidavits, they are a part of this compilation also, my lordship. At page number,
Your last
page 931. It starts from 931, my lordship, of the second compilation.
Because in this affidavit, you made allegations against them that they're running a.
Yes, my lordship. They haven't tributed against those for the first time. In their rejoinder affidavit, my lordship, on 26/5/2025, they only meant to state that no, this is not the case, and the court has observed. But in my rejoinders dated 22nd of August, my lordship, I have clearly stated, and on proof, it is proved that the court did not observe any independent observing.
There was
from
some
there.
other proceeding against you in Assam, right? What happened to that?
My lordship, all the GST proceedings are over, my lordship, and none of the GST proceedings have concluded that the invoices are fake.
Fake.
Yes, my lordship, and the police proceedings, those proceedings have been halted by the Guwahati High Court, my lordship. 3 proceedings have been halted by the Guwahati High Court after finding that yes, the state of Assam was vindictive and there were wrongdoing on the part of state of Assam, my lordship. Right after the orders were assigned, like once the report of Assam was submitted and once we filed the rejoinder, my lordship, they assiled by the orders. Now they cannot, because once we said that the coal has come from Assam, once the petitioner is not getting.
Yes. See, the thing is that, see, what we feel also, see, we cannot let your personal kind of animosities or enmity, like, cloud the entire issue. Now you actually also, it's mostly making personal allegations against the petitioner, and his cohorts, a kind of thing, that they also that you have some sort of a, I don't know from the records what.
In fact,
you
an
can see
affidavit
that
was
there's a
withdrawn
business
also.
rivalry, or what kind of rivalry we don't know.
He had filed an
But it
affidavit.
manifested itself in such a manner that it's taken on this color. And now earlier on, I think this matter was supposed to be referred to the committee also with regard to that certain aspect only about the origin of coal, but he had resisted that.
Yes,
I think you had said, Mr. Day or yourself has submitted at that point of time that's not similar to the other PILs.
Because that was nothing on the inventorized coal, all the seized coal, Lordship.
Exactly. But then the thing is, now if we let this, what are we to do? Then because
If I may play, Lordship,
you have personal agendas.
Lordship,
my Lordship.
he had, if your Lordship would recollect, he had filed an affidavit naming certain lawyers and certain people. That affidavit has been withdrawn by him.
Withdrawn because this court didn't want to go into that.
Lordship,
We were
now,
on a different issue.
even
We
I am-
want your personal agenda.
Absolutely,
We know
Lordship.
to.
We are digressing from the issue, Lordship. What I may submit,
to.
My Lordship,
absolutely, Lordship. What
the
I may
onus of
only
proof squarely
submit.
lies upon them that,
But
that it was a illegal coal.
see, the thing is that, Mr. Bhav, we have to. The court can't just sit. We have to
Yes,
take
my
some
Lordship.
direction forward.
Yes, my
Either we
Lordship.
close the matter or we pass other effective orders, leaving aside your personal
Lordship is-
vendettas and agendas and. That's
Lordship,
the only
what
thing.
I
So
may
what
humbly
we see
submit
that
is, Lordship, that
it's replete with that.
Lordship, there are respondent number 3 and 4 and 5 are the.
What about the FIRs and cross FIRs? We all file against each other. It's all existing, correct?
I have not filed any
My,
FIR.
my Lordship, my FIRs have been FR'd because no action has been taken against their personal persons who have copied our invoices. In fact, they have copied our invoices and exported the coal. We have annexed those FIRs in writ petition of Michael T. Sangma.
Not the petitioner. He is talking about some XMLA and this and that, Lordship. What it has to
No,
do
my
with the
Lordship,
petition?
that was tagged along with this PIL very well on the first date of hearing itself. That all questions are open to that writ petition. And they were the set of advocates who were representing him also, my Lordship. So they cannot simply say that.
You don't want to go there.
Yes, my
The thing
Lordship.
is that she is a PIL.
Yes, my Lordship.
Correct, a PIL, right?
Yes.
It's supposed to be non-adversarial. If you brought notice of the court, it's your duty also to, not to champion your own,
Absolutely,
your
absolutely,
own grievances,
Lordship,
your own right.
absolutely.
It's a question. Okay, PIL is in public interest. You brought notice of the court,
Absolutely.
asking for the court to pass some orders, but you can't be stuck in this kind of deadlock. We just counter allegations.
Absolutely. That is why I again submit, my Lord, that what I am submitting at this stage,
My
Lordship,
Lordship,
that
the video footage which they have shown.
Okay,
earlier,
no, let's go there. Yes,
that's
what do you have to
court,
say?
there appears to be some dispute which he has with the status of the cases in Assam and the report filed by Assam. Lordship, the DGP of Assam as well as the Director of Gearing and Mileage and Commissioner of Taxes are party in this petition. Let them be put to notice. They were appearing at earlier point of time. I'll inform them, Lordship, personally. It can be taken up. Let them clarify on that part, what happened to those matters. And as far as my grievance is concerned, Lordship, my only grievance is that let him show that document and that PIL may be closed, Lordship. Why is he shying away from showing a
My
document to
Lordship,
show that this is the
his
mine?
request was simple that I should not be allowed to trade. If you see the prayer
Because
of the
it doesn't
PIL, my
have a
Lordship, all the 4 prayers have already been taken care of, my Lordship. The 4 prayers which we have made in
anymore
prayer.
now.
No,
My Lordship,
because
no,
he
my
could
Lordship,
not-
from last 4 years, I have even not been able to participate in the auctions which are taking place in Meghalaya, and whichever auctions also I participated, they blocked those
I
on the
am
name of the
sure.
PIL.
There's
On
an
the name
order by
of
this court.
No, my Lordship, the order was, in that affidavit, I have very clearly mentioned how that order was passed. If the embargo was regarding that thing, in the subsequent orders, it was very well cleared that okay, no coal should be exported without telling the source by the respondent number 14. It was very clear. So, in a manner, if embargo was there, so why are they not telling the court true facts, which I highlighted in my affidavit, last affidavit, my Lordship.
There is an injunction order against him passed by this honorable court, Lordship.
My-
Why that was
My
passed, I
Lordship,
don't wish to
that,
comment on
that,
it.
that has been very well explained on the affidavit of 12th March 2025, my Lordship.
He has
was
not
due
filed
to-
a modification application till date,
Oh, we are aware.
Lordship. Let the this respondent 3, 3A and 4, Lordship, these are respondents from Assam.
My Lordship, they
can
have
come and
already
clarify
filed.
it.
My Lordship, the affidavits have already been filed by them, and there were rejoinder from my part in 2023.
Complete.
Lordship, yes.
Yes.
Because I don't wish to file any further rejoinders and affidavits, Lordship. It doesn't go anywhere.
Yes. stop. Right. What order? 14th March 2023.
Lordship, 20. I'm sorry. That is Lordship. 25. 25/4/23, Lordship. 11/4/23 is the first order I was. 11/4.
Yes. This court, on hearing the parties, and it appears after countless affidavits and rejoinders have been exchanged, filed and exchanged, the issue that still remains is with regard to the question that had been flagged by this court, leaving it open to the respondent of 14 to file a further affidavit if necessary to indicate the source of the quantity of coal. Stop. Next paragraph. Though Mr. Y. Bhama, appearing in person today, has reiterated his submission that this query has been answered by way of the GST invoices that have been annexed to the affidavit dated
My lordship,
25/4/23.
25/4/2000.
25/4/23. On the other hand, Mr. S. Deb, appearing for a PI petitioner, has countered this submission by stating that this has not met the query as to the source and origin of the coal. Stop. The parties have also made reference to the reports filed by the police in Assam, who are also added as respondents here, which Assam, which have been annexed to your.
This is in.
It was produced
part
by
two.
whom? By the affidavit.
Lordship,
Yes,
it's
my
filed by
lordship, they are
No,
filed
by
by
the police itself.
by the police
which,
itself.
which
filed by
has
way of
been
affidavit.
filed before this court by way of affidavit. Lordship. Thanks for today, as noted above, as the question still remains, it is felt desirable to bring a closure to this matter that the presence of the respondent's number, Assam Police,
Lordship, they are.
Money
three-
Geology in Assam,
Lordship, respondent number 3, 3A and 4.
respondent number 3,
3A.
3A and 4, who they are, be re-put to notice to appear to assist the court in this matter. Stop registry as well as the parent petitioner to take appropriate steps or to take steps to intimate and notify the said respondents. So, when should we list? We list it again. Otherwise, we let them come, we'll close it.
My,
Otherwise, this way or that way.
Lordship.
If they can't
My
see
lo-
anything, we'll close it.
my lordship, let this PL, even if they wish to prolong this PL, I don't have any issues. The only issue is like since 4 years my business has been hampered, my
No,
lordship.
let them come. Yes, list when?
After 2 weeks, Lordship, in the meantime, I'll take.
It's about 3 weeks. Give him some time.
Lordship.
Yes.
Lordship.
To intimate them to present on the
Lordship. Obliged.
Any mention?
My please, Your Lordship. Your Lordship, I beg to mention item number 35, Your Lordship. This matter is fixed for referral, Your Lordship. However, the respondent number 2 is not agreeable to mediation.
And respondent number 1, Your Lordship.
It can come
Number
up
two
for
whom?
Private.
Mr. Goyal is appearing, Your Lordship.
So when will you have for here? When you going to fix?
After 3 weeks, Your Lordship.
Okay. Yes.
Good day, Your Lordship.
My please, Your Lordship. Your Lordship, I beg to mention item number 41, Your Lordship. Let it come after 2 weeks, Your Lordship.
I have no objections, Your Lordship. Please. No
Objection?
No.
Why are you taking adjournments all the time? Okay.
Highly obliged, Your Lordship.
May it please your lordship, I beg to mention item 42, your lordship.
Who's for the other side? Yes, Ms. Colney.
Yes, my lord, she has already informed me. No objection, my lord.
What's the matter about?
This is about regularization.
Why you take time? Yes, okay.
Mr. Blake.
May it please your lordship. So with the consent of the other side, I beg to mention item number 38, my lord.
38?
38. Matter may kindly be taken up after 2 weeks, my lord.
My lord, I have no objections.
Much
Please your lordship, I beg to mention item number 33, your lordship. Item number 33.
No objections, my lord.
Sabindra, ba?
Yes, your lord.
May I please, Your Lordship, I beg to mention item 40 on behalf of Mr. N. Dasgupta. I've taken consent from the other side for 2 weeks, Your Lordship.
Objection?
No objection, your lordship.
40, Your Lordship.
Okram Durendro?
Yes, Your Lordship. On behalf of N. Dasgupta. Obliged, Your Lordship.
Lordship, I beg to make a mention. I think. Oh, Lordship. Sir.
Why?
Lordship,
Let it be a joint prayer, my lord. Mr. Pandey and senior counsel are both in another matter, my lord. They are tied up today. So we are praying, we are making a joint prayer for adjournment, my lord.
When?
2 weeks.
Everything's 2 weeks. So why does all half anyway?
No obliged.
May I please your lordship, I beg to mention item number 36.
Told this being adjourned. Yeah, objection, Mr. Sangma?
Seems the council is sick. It seems under medication.
Ms. S. Sun, lordship.
Yes.
But much blessed, lordship.
Item number 1.
What is this with you,
My lord, item number 1 to item number 6, my lord. These are the similar matters, my lord. There's, we are seeking for regularization, my lord. The department is a social welfare department, my lord. So
how long have you been working?
They have been working, my lord, since 2009 and 2010, my lord.
Ad hoc?
Ad hoc, my lord. Ad hoc, and there was no break, my lord. There was no break. So they have been continuously working, my lord. And in fact, their names were also recommended, my lord, by the cabinet, but they were been left.
That means 10 years.
I'm
You've been working over 10 years.
More than 10 years, my lord. Some of them
Yes,
are 15
that's
years.
Yes, my lord. 10 to 13 years. But
Okay. Right, Mr. P, you've been issued notice. All state respondents only.
Yes, my lord.
MSOI Bank also is present, receives notice on behalf of all the respondents. No further notice called for. Just after 3 weeks for instructions are affiliated.
1 to 6 are connected.
7.
Obliged.
But I had you prepare the way you propose. Yes.
Please, Lordship. Lordship, we are agreed by the action of respondent number 7, who is headman of Motion Ram, my lord, in not giving NOC for business, my lord. But here what happened, well, the petitioner is a company engaged in what they call, my lord, if I just take your lordship to page 24.
Yeah.
Page 24, my lord, Annex 3. We have been awarded this contract, my lord, for input-based distribution franchisee in Mosinram, Nangal Bipla and Full Public subdivision under pursuant to NIT, my lord, floated by MEPDCL. We are H1 bidders, my lord. And we have been awarded this work. Now, Headman Mosinram is not giving NOC to enable us to get the non-tribal trading license, my lord.
So you can't work now?
Now, my lord, we set up an office, they came and closed down the office, my lord.
Who closed the office?
The headman, my lord. We filed an FIR to that effect, my lord. Page 20.
But a contract under the MPDCL.
Yes, my lord.
So the thing is that why they're not coming to your assistance?
Page 28 is the
Then how can let this happen? Suppose this works for public it's a public service.
Yes, my lord.
They just engaged to provide this what work they're doing.
My lord, this is a franchisee for distribution, my lord. But under the new scheme, what they've done, my lord, for every area they have given on franchisee basis.
Yeah, of course. I mean that is for the electrification of the villages.
My lord. Not for electric, for distribution, my lord.
Okay,
For the existing.
Yeah, but
Now, my lord, under the new economy, my lord, when there are reforms in electricity sector and this kind of
it should happen, my lord.
But it happened because this these NGOs who also are serving out here, going and harassing people. They are silent on real issues, and
And this company has nothing to do with the individuals, my lord.
Exactly,
Because they'll be paid by MEPDCL. Contract is been awarded to the MEPDCL. All their transactions are with MEPDCL
it's
only.
for a government contract. I don't think trading license should be required at all.
My lord.
Just implementing it. You can't go harassing the. Yes, it's for the good of the people.
Notice may be issued to the admin.
Yes.
Serious.
Very serious. Yes. Who's appearing for the state?
The state also should provide.
Yes.
Adequate.
Otherwise, we provide security.
Adequate protection should be given.
It happened at the LPG bottling plant. That bottling plant would have come up. PIL was filed in the court. Bottling plant was there. Have NGOs going demanding money right and left no time inception. Then finally some better sense prevailed. Put a police picket there. N number of NGOs coming with what it demands.
Moreover, this regulation, what it says, my lord, when it's the regulation, what it says, my lord, is, I'll just read one provision, my lord. Page 35, my kindly see, my lord.
You're depriving, by this action, the headman or depriving their own people.
Page 35, regulation 3, my lord. Control of trading by non-tribal. No person other than a tribal resident in the district shall carry on wholesale or retail trade or business.
Yeah, Mr. Dindo, you just also you have to meet, because it's not a retail wholesale business. It's a services.
They have already obtained trading license from the Garo Hills. No? They've annexed it.
Because
they've got 3 areas.
So and from Garo Hills we are operating them, my lord, and
they have obtained the trading license also.
Just heard Dr. N. Morse, candidate, senior counsel, for the Special Assisted Vice Minister. Mr. Tirendo, Mr. J.K. Pariat is state who's there?
SKH Nangrum.
Yes, SKH Nangrum.
1, 2, 3.
I think Mr. Shula, you better appear in the matter. It's serious. You just give it to a panel lawyer.
I'm not a lawyer, sir. Let me have it, sir. In the matter.
Of course, I'm just put notice you appear. And you made Advocate General appear also.
Lordship,
yes, I'm not heard so. Mr. Andy Shulail and AG was also present on behalf of respondents
1, 2, and 3.
1, 2, and 3. No, and 4, Mr. Jendanja,
4, 5, and 6.
And Mr. DJ Rendo with Mr. J.K. Pariat on behalf of 1, 5, and 6. No further notice of respondents. Notice to issue to the number 7 within 3 days. Stop. In this writ petition, the grievance of the petitioner which is the company engaged in providing consultancy and technological services in the power sector, is with the
Distribution franchise.
who has obtained distribution franchise for
Distribution of electricity in Mosindram block.
under the respondent number
4
MPDCL. Bolivia. Sector
Distribution franchise.
and who has obtained distribution franchise from one of MPDCL is with the respondent number 7, Headman of Mosindram, who it appears in a matter that concerns public which concerns distribution of electricity for public good, has not issued an NOC
To enable him to obtain trading license.
to allow the company to obtain a trade license. So, they submitted by Dr. Mozika that when the company set up an office, to start the operations, the headman and
Some NGOs.
some NGOs, local NGOs, have shut down the office.
Yes, ma'am.
Have shut down the office, and this has affected not only the functioning office, but the schedule for putting in place the distribution system. He praised that he has also submitted that it is not a question that he also admits that though the companies applied for a non-trading, for a tribal
trading license.
for a what's that? For a trading license under the
S34.
under the trading by non-tribal regulation of 1954. The same would not actually apply, as the company is not engaged in any wholesale retail trade and is only providing services for the supply of electricity to the concerned area. Next paragraph. Mr. T.P. Dingdo, learned senior counsel, appearing for district council, submits that appraiser may be allowed to obtain instructions. It hasn't reached your table also, that means?
No.
No.
Because it has to go, the headman has to give a NOC.
Yes, I and the Shulai. Ms. N. Shulai learned AAG for the response 1, 2, and 3. He submitted that he will take immediate, that the state respondents will initiate immediate inquiry into the allegations made by the writ petitioner, as the action of the respondent number 7 is totally against public interest. Mr. Tirindo also pleaded allowed to obtain instructions as to whether in such contracts a trading license will be required at all. In this view of the matter, after 1 week, the headman registered to direct for service notice on the headman through the officer in charge of Mosindram Police Outpost for appearance on the next date. List on. Let's go to March. This on 3rd of March. 3rd of March.
Item number 8.
Please, Lordship. Lordship, this is pertaining to the VAC, Village Employment Council. Your Lordship, what happened in this? The BDO have issued a notice for conducting that election. On the basis of the notice issued by the BDO, election was conducted and the result was declared. And the petitioner hearing was declared, and then their BSc functionary was approved on the basis of the election. And thereafter, the private respondent have challenged the approval order of the BSc functionary issued by the BDO. Now the writ petition was filed. The writ petition was dismissed. Their petition saying that they have suppressed the facts, suppressed the serious suppression of facts. And against
suppress what fact?
Because they have resigned. Earlier.
Who have resigned? Is you?
No, the private respondent. They have resigned.
Who brought first the petition?
First they filed a writ petition. May I take you to that is earlier order also, Lordship. That is page 39, Lordship.
Okay. What happened? They suppressed.
They suppressed the fact.
Can I page yourself?
Yes, the number is.
They resigned.
They resigned because they resigned.
Yeah.
And then, because of their resign, the BDU have issued a notice for fresh election. So in the fresh election, we were elected. Then after that, against that order of the approval of election, they have come and filed this petition, and it was dismissed. This is the order. And against this order, they filed an appeal. That I have election. In the appeal, nothing was stated. Only say that let there be an inquiry. Only that one. Then. After that, it was within 6 months. Then during the inquiry, there was no inquiry. No inquiry was conducted, and they have issued another saying that they have allowed the private respondent to continue as a VAC functionary.
After they resigned, they are continuing again now.
They are continuing.
And you were elected, and you've been removed.
Yes, we are removed. Kindly see the page 46 and 47. How the BDO have done the conduct. There was a inquiry conducted on 14/01/2003. That time the statement was taken.
So this Sonalin and Sangma and Jenny Marak, they resigned.
They have resigned.
How is it possible to say?
My lord, here that is the allegation, lord. That is why.
What allegation? If they suppress, they resign.
My lord will see the division bench order, lord.
From different villages, because here only thing is that.
They are from different village or from same village?
We are same village.
So they dismiss the review.
No,
same village, how?
No, they were saying that we have no locus standi to file a petition.
Yes.
Because they were saying that since our election ID was recorded, but in the review petition, because the election ID is even the private respondent also having the same election ID, that the constitution election is the same. But only the VAC is the VAC of the review petitioner and also the private respondent, we are the same there. But that's why we have bring on to the record also that there is no bar, because we are also the job card holder of that particular village, because it is on record, your lordship, because it is finding. Because only thing is the earlier occasion we failed to inform to the court, because only the both polling station was different.
Yes, that correct, Mr. Shulai?
That was correct.
Lordship, earlier when they filed the petition, the private respondent, they filed affidavit, your lordship. They have not challenged that statement, your lordship. Lordship, kindly have page 20 of the review application.
Yes.
This is the
pick up.
Lordship, yes.
Oh, what is this? Sorry.
This is the affidavit, your lordship, filed by the private respondent, your lordship. They have not contributed.
No, where's the affidavit? What are you talking about? Page 20, you saying?
Page 80, your lordship.
80?
80, your lordship, yes.
Which paragraph they are not contested?
Only here they have stated
They have not challenged.
They have not in the cost title.
Which cost title? This cost title is
No, this para 2 of my review petition I have clearly mentioned, Your Lordship, all those this one, this the page. Next one.
No, let's recall first the order. Recall the order first, whether they can proceed. You file affidavit, then within 2 weeks. Yes, MS Rahman pays for 5 to 7 days or not. So 2 weeks you file affidavit. I'll review Mr. Sangma.
12.
Lordship. Yes, Mr. Kumar.
My lord, item number 12, my lord, contempt against the order dated 25/9/2024, my lord, non-granting the benefit of ACP and MACP to the cipher category, my lord.
In fact, there are similar orders passed by this Honorable Court and Guwahati High Court also. So in the process of complying because of huge financial implication and interdepartmental consultations required. Please this instruction.
The Lakshman Ramjat, the one who should serve as protocol officer here.
Yes, my lord.
There are many petitioners in this case, my lord. Hundreds.
No, only 18, my lord. 18 petitioners are in this petition.
Just place this instruction.
Then you file the affidavit. A communication dated 29 Jan 2026 has been produced by the London DSGI. But it doesn't mention this one.
It mentions about the Guwahati cases, but all are being taken up together.
Yes. Which indicates that approval from the Ministry of Home Affairs has been obtained, and administrative order for implementing various court orders regarding cipher cases, including the subject cases, have been forwarded for approval of the GAR. It is submitted that, it further states that on receipt of the same, we approve by DGR, subject judgment and order will be complied at the earliest. Dr. Mozika submits that the person involved with
large number of persons.
A large number of personnel is involved to implement the order may require some time. However, directed this submission is noted. However, the learned counsel is directed to place the communication by affidavit.
My lord, deep your lordship.
13.
Place the commission on record by affidavit.
13.
My lord, here I am supposed to file an application, my friend. That is supposed to give the name of
Where the further necessary party?
New secretary, lordship.
Mr. Peter Marak, it is written big board, my lord, in the office. If my friend is
my lord.
Why should you ask?
Why?
You should know.
Yes,
he's supposed to know.
What's 1 week's time to file the appropriate application.
So you should give the name, lordship.
That's between you and him.
Lord.
14.
So she get a season counsel.
14.
Similar item, lordship. This is also.
Similar prayer.
Simple.
13, 14, 15.
Not
15.
15 is what?
Well, this they have paid, my lord. They have complied with the court's order. Can be closed.
Mr. SD submits that as the order has been complied, nothing remains for consideration. Only contempt application is closed. Disposed of.
16.
Please, your lordship. Your lordship, I need some more time to file my rejoinder, your
How many
lordship.
times you prayed?
You have no idea.
Lordship. Second 2 times.
Second? How many times asked for rejoinder?
How many times?
2 or 3 times. By next day, Your Lordship will be filing it.
16/7. Any okay. Response allowed. 2 weeks time is asked opportunity to file rejoinder.
Highly obliged, Your Lordship.
17.
17. You have the our affidavit, no? What will be filed?
Lordship, this can be posted for final hearing. In the meantime, if
rejoinder.
My Lord, I just now I have seen the counter affidavit, Lordship. In the meantime, if required, I'll file, Lordship.
Yes, Mr. S. A. Sheikh plays a matter of this hearing, and he may also going to file rejoinder. This after 3 weeks.
3 weeks. I don't think that, because this is a covert case, Lordship, that Home Guards, that revision of pay.
What's the matter?
That earlier matter, that revision of pay, Lordship. My Lord has granted that.
18.
If this lordship, I'll be filing my rejoinder during the course of the day, my lord. It's already been prepared.
Mr. Peter Sambas, rejoinder can close the day just after 3 weeks for hearing.
Lordship, must bless lordship.
What's for hearing?
Yes, I'll file today. Must bless lordship.
19.
Lordship,
Settlement successful?
No, Your Lordship. I require one week's time, Lordship.
See your last order.
Yes.
Settlement didn't work. What's the matter about?
It's about a retirement benefits, Your Lordship.
Which department?
Corporation.
Corporation?
Yes, Your Lordship.
MSS Lalu submits as the settlement talks
Settlement is there.
were not. What settlement talks? What did Ms. Caroline say last time? Settlement for his pension?
Lordship, I just received the brief this morning.
You said as settlement talks, as it reported that settlement talks not successful. 2 weeks time allowed to the want to file affidavit.
Much of it. Deeply obliged.
20.
I'm for respondent number 6 and 7. We file our affidavit.
But we are likely to file it today.
Likely? I like that submission. Number?
6, 7 and 8 has filed.
What's the matter about?
School matter, Your Lordship.
School matter, my lord.
We have challenged here the impugn order dated 22nd 11 of 2024.
Mr. SD appearing for respondents?
6 and 7.
6 and 7. Submits that affidavit has already been filed. So also Mr. Dev for 8. As also Mr. S. Dev for number 8. Mr. Kibashi submits that contracted respondents have to file the course of the day. Yes.
Obliged.
Just after a week for a joint of any.
21.
I have received the copy of the affidavit, my lord. I need 2 weeks' time to respond if there is any.
It's been filed since 30th of January.
My lord. No. I received it just on the last date, my lord.
Yes, jury joinder.
I'll see if there's any.
Mr. N. Masuri wants to please wait out. To examine the affidavit filed by state respondents and to file a joinder if necessary.
Obliged.
Obliged allowed just after 2 weeks.
22.
22 also same.
23.
May it please your lordship.
Yes.
Your lordship, the respondents are supposed to file their affidavits.
You're not file affidavit now.
Lordship, some
Why?
developments have come up.
What development?
Lordship, the petitioners have dug up some
using a JCB within the suit land in title suit number 50, and we have filed an FIR. So, Your Lordship, we'll file a affidavit on the next date.
Yes.
Your
What
Lordship.
stage is title suit? You
Yes,
file a
Lordship.
title suit.
They have
Yes.
filed.
What stage is it?
It's stage of framing of issues.
Any injunction operating?
Injunction, initially there was an ad interim injunction. After the matter was heard, the injunction was
Injunction was in your favor.
was set aside.
That they are in possession of the land.
No, Your Lordship,
Your Lordship, if I may humbly submit, Your Lordship, we are aggrieved by the refusal and denial of respondent number 1 and 2. They refuse to issue us benefits to secure basic civic amenities.
No,
Like-
see, the thing is that the last date is submitted by Mr. Thapa that your allegation is not correct. You've not been ostracized or been deprived any benefits. But is that a fact?
Your Lordship, we have brought it on record, Your Lordship.
Yeah, you file affidavit within 1 week. Otherwise, you can't ostracize or.
No, we haven't.
We have brought it on record, Your Lordship.
There's
that
been
they have
no
stated.
ostracization.
They are denying us. They are denying us of certain to avail basic
Yes,
civic
sir.
amenities.
Your name?
W. Dakhar, Your Lordship.
Mr. Dudakar, the petitioner submits that the respondents 1 and 2
Yes.
are still indulging in depriving the petitioners of their due benefits in the village. The same is refuted by Ms. Lee Thaba, respondent 2, who submits that no such action is being taken against the petitioners. He prays without to file an affidavit, and then he also prays for further time to file affidavit stuff. This court notes that prayer is allowed. However, this court notes that if such situation exists as recorded in the earlier order dated 17/12/2025, Mr. D. Thapa to ensure that the respondent 1 and 2 do not engage in any activity of authorization or to deny the due benefits of the bona fide residents of the village, right?
Yes.
Yes, of the bona fide residents of the village, such as the petitioners. Yes.
2 weeks.
Okay, 2 weeks. But you advise their clients.
Highly obliged, Your Lordship.
24.
Lordship, in this case, I received paragraph's comment and everything was done, but one paragraph has to be corrected, so I have sent for further clarification. So I may be given 1 week's time. I'll be filing with
One paragraph only.
Yes, that's
Where's the office?
PWD, Your Lordship.
In Shillong?
Shillong, yes. Your Lordship.
When did you send it?
Yes, last week Friday. I have sent it back. I actually
Okay, 1 week
invite.
further time as prayed allowed for.
Hello, please.
25.
Your Lordship, the government has placed the affidavit, so we need some more time to.
What is the matter about?
This is a matter about the contractual teachers. Thereafter terminated by the state government. So they have placed the affidavit. So we'll.
What do you see in affidavit?
Lordship, they have no right whatsoever.
How long are you all working?
We are working. Some of 10 years. Some of them are
At
7
that time,
years.
they don't have
Yeah.
the required qualification that is accepted.
That because the government did not
Subsequently they passed that, Your
did
Lordship,
not
and they
conduct the
came appointment
that
for
exam.
them.
So that's the issue.
You obtain your qualification later?
Yes,
Yes. Anyway, so you want to file a rejoinder?
Yeah, we will find a rejoinder.
As a case, please notify the rejoinder to the applicant file. My state respondents list up to 2 weeks.
If your Lordship allowed that indicates the date, so that we will file a rejoinder and we'll please for hearing.
File it first. Yes. We can hear in the dates, then.
Much
Have a past rule that matter can't be disposed of any stage.
26.
Yes.
Pertains to non-communication of ACR, my lord. Otherwise, this is a covered case, my lord. My lord has passed the so many.
What is the relevant period?
Relevant.
21, my lord. So you'll find that page 21, para 4.
It was not communicated. Where's the early order? But it's both of them. Yes.
My lord.
Yes. Which part order is it?
My lord. Deeply on.
27.
Please, Your Lordship, I prefer 2 weeks time, Your Lordship.
You?
Yes, Your Lordship.
What's the matter about?
Regarding where the petitioner did not get to appear the exam and also they have been cancelled the entire semester.
Which department?
Law Department. Law Department.
Law department. You came before whom? Not before.
I've taken step for the respondent number 8 also, Your Lordship.
Number 8, you've taken steps.
Yes, Your Lordship.
Who's the bill number 8?
UGC, Your Lordship.
Wakalat nama Sonia Langstay. Oh, that S Langstay. Yes, MS Chalam 127. Vice. Should I advise S send or not necessary?
Yes, sir.
Just write this for her name. Yes, correspondence 127. Praise for how much time?
2 weeks time, Your Lordship.
2 weeks time to file affidavit. Praise allowed. It is noted that the respondent pay has been served and is being represented through MS Langstay. There is no appearance on behalf of respondent today. This is after 2 weeks for the orders.
28.
My lord, service not yet completed.
Why?
I'm entering appearance, Your Lordship, on behalf of the
All
respondent. This private respondent. This one respondent is there.
May kindly grant
one second. You're the sole respondent?
Yes, Your Lordship.
Yes, sole respondent.
You're so what?
A copy of the petition will be served for me, Your Lordship.
You have not got a copy as yet?
No, Your Lordship.
Yes, Mr. Pasanteev has done an appearance today on behalf of sole respondent. He, however, submits that the recorded petition is yet to be served on the council.
It was sent.
No, send means you give an extra copy.
Okay.
Mr. Elam Samba undertakes to supply an extra copy of that petition along with annexures to the council within 1 week by the course of the day. In the course of the day.
Okay.
Just after 2 weeks for affidavit or
Highly obliged.
29.
a writ petition against a private person.
Yeah, private.
Okay.
29.
My lord, please, Your Lordship, I'm waiting for the status report, my lord, on the investigation. This is a scam case.
What about
HDFC Bank.
additional parties?
Additional parties are ready, my lord. I'm just waiting for the petitioner to arrive so that we can file it. My application is ready, my lord.
Who's paying for the respondents? Mr. K. Khan with H. Karwanlang.
Mr. Karwalang is not well today, so he's not there. Mr. Karwalang.
Mr. Khanwanlang.
Karwalang is my lord.
Yes.
He's not well today.
What to do?
Status report.
When are you going to add other parties?
My lord, I'll add it today. I'm just waiting for the petitioners to.
OA Bank submits,
They're coming all the way from.
That she'll be filing the application for the addition of additional parties.
I'm praying for some time, Your Lordship, to seek instructions.
Imagine every place for the place allowed to seek for the instructions. This after 1 week. Right.
30.
Where's Mr. Pasanteev just now was here?
Respondent 7.
Who's appearing in the sum 7?
Sir, Shila's
Jeshila, you or Pasanteev?
We were there, Lordship. Mr. Shila's executed of Kalanama, but also on record, Lordship.
You appearing?
Yes, Lordship.
Yes.
Lordship, the notice was issued to the executory based on the inquiry.
We've not been given a copy of that report, Lordship. And it was to file the affidavit.
Lordship, the inquiry is conducted by the state. The state will should supply, Lordship.
You have a copy of the inquiry report?
Lordship, I have.
Mr. Harkang, for the conversation service that is that. What do you pray for? Affidavit?
Yes, Lordship, will be filed.
Please for further time to file affidavit. He also submits that he is not yet in possession of the inquiry report dated.
Okay. Jangan. $30.9, your Lordship.
39/2025.
Lordship, yes.
A copy of the same to be made over by the Leonard GA to the council. It's just after 2 weeks for affidavit.
31.
That also will come along.
Yes, together.
32.
Apply, your Lordship.
32
same, your Lordship.
Consent same VC, Lordship.
Hearing. 39.
Yes.
I were to show to your Lordship's judgments
Yes.
on the aspect of concealment. Please, your Lordship would have the first judgment. Please, your Lordship, that's a judgment of the Supreme Court, Ravinder Kumar versus State of UP, which was
Yes.
dealing with this very issue. Your Lordship would have paragraph 1 itself. The vexed question is back again. Is it a hard and fast and a cut and dried rule that in all circumstances non-disclosure of a criminal case in which the candidate is acquitted in the verification form is fatal for the candidate's employment? We think not, and it ought not to be so too. Fortunately, we have a judicial chorus supporting our view. Each case will turn on the special facts and circumstances. We have endeavored to analyze the applicable precedents and have followed those lines of cases which have a striking similarity to the facts at hand. Then your Lordship would have para 28. After looking at all the judgments, including the judgment of Avtar Singh, which my learned friend had relied upon, please, your Lordship would have paragraph 28.
Yes.
Yes. The nature of the offence, the timing and nature of the criminal case, the overall consideration of the judgment of acquittal, the nature of the query in the application verification form, the contents of the character verification report, the socio-economic strata of the individual applying, the other antecedents of the candidate, the nature of consideration and contents of the cancellation termination order are some of the crucial aspects which should enter the judicial verdict in adjudgment suitability and in determining the nature of relief to be ordered. Then your Lordship would have paragraph 30. On the facts of the case and in the backdrop of the special circumstances set out here and above, where does the non-disclosure of the unfortunate criminal case which to ended in acquittal stand in the scheme of things? In our opinion, on the peculiar facts of the case, we do not think it can be deemed fatal for the appellant. Please, Your Lordship, may note the next very line. Broad brushing every non-disclosure as a disqualification will be unjust, and the same will tantamount to being completely oblivious to the ground realities obtaining in this great, vast and diverse country. Each case will depend upon the facts and circumstances that prevail thereon, and the court will have to take a holistic view based on objective criteria with the available precedent serving as a guide. It can never be a one-size-fits-all scenario. Please, then your Lordship would have the second judgment. This is closer in fact because this was also a case where the candidate subsequently himself on his own had disclosed the criminal case. Please, Your Lordship would have, this is a short judgment, paragraph 3.
Yes.
brief facts which are necessary for deciding this appeal are that the respondent, while seeking post of a constable during the special recruitment drive, is alleged to have concealed from mentioning in the application form against a relevant column that there was a criminal case pending against him. He had put a cross mark in the relevant column. The application form was submitted by him on 21/27/8/1995. He was provisionally selected after passing the written test, physical endurance test, and was interviewed pending verification of his character. However, before any order of appointment could be issued in his favor, he, realizing the mistake, wrote a letter to the Deputy Commissioner of Police in which he inter alia stated. Then your lordship will see that he had disclosed in this letter. Please, your lordship would then have paragraph 5, that there was an omission on the part of the respondent to give information.
Why are you reading this? The judgment. This is the Delhi High Court judgment.
Yes. Please, your lordship, this is there is a Supreme Court judgment also. Commissioner of Police versus Dhaval Singh.
No, it's not been given. Where is it? You flagged it wrongly. That means. 1 second. Yes. The Delhi High Court. I'm wondering where you're reading from. Oh, she's put as a large judgment, 99 years. Yes.
Sorry. Please, your lordship would have paragraph 3, which notes that first he had not disclosed and then he had himself written a letter. Then your lordship would have paragraph 5. That there was an omission on the part of the respondent to give information against the relevant column in the application form about the pendency of the criminal case is not in dispute. The respondent, however, voluntarily conveyed it on 15/11/1995 to the appellant that he had inadvertently failed to mention in the appropriate column regarding the pendency of criminal case against him, and that his letter may be treated as information. Despite receipt of this communication, the candidature of the respondent was cancelled. A perusal of the order of the Deputy Commissioner of Police cancelling the candidature on 20/11/1995 shows that the information conveyed by the respondent on 15/11/1995 was not taken note of. It was obligatory on the appellant to have considered the application and apply its mind to the stand of the respondent that he had made an inadvertent mistake before passing the order. That, however, was not done. It is not as if the information was given by the respondent regarding the inadvertent mistake communicated by him after he had been acquitted by the trial court. It was much before that. It is also obvious that the information was conveyed voluntarily. In vain, we have searched through the order of Deputy Commissioner of Police and other record for observation related to the information conveyed by the respondent on 15/11/95 and whether that application could not be treated as curing the defect which had occurred in the form. We are not told as to how that communication was disposed of either. Did the competent authority ever have a look at it before passing the order of the cancellation of candidature? The cancellation of candidature under the circumstances was without any proper application of mind and without taking into consideration all the relevant material. The tribunal therefore rightly set aside. We uphold the order of the tribunal, though for slightly different reasons as mentioned above. Then your lordship would have the Delhi High Court judgment. Please, your lordship would have paragraph 2. This was also a similar case where the petitioner had, where the candidate had himself voluntarily subsequently informed. Please, your lordship will find that at paragraph 2, the facts emerging from the record that are necessary for the adjudication of the present petition are as follows. The respondent on 12/6/2017 issued an advertisement inviting applications of filling up 124 vacancies to the post of junior judicial assistant restorer and for preparing a panel for future vacancies. Subsequent to the aforesaid advertisement, the petitioner filled up an online application form where he was categorically asked if he had ever been arrested, prosecuted, kept under detention, or bound convicted by a court of law for any offence. It is a petitioner case that he had inadvertently answered the aforesaid question in the negative. At the time of submitting his online application form, he states that on 18/3/2013, long before the issuance of the aforesaid advertisement, a misunderstanding took place. Then this is about the case. Then your lordship would have paragraph 4. It transpires that the petitioner successfully cleared the written test conducted for making selection to the post of junior judicial assistant and by the letter dated 19/12/2018 was offered appointment to the aforesaid post and was asked to submit his acceptance within 15 days. The petitioner submitted his acceptance on 5/1/2019, and by the said communication, he also informed the respondent that a criminal case arising out of FIR number so and so had been registered against him on 19/3/2013, in which he stood acquitted. The petitioner also submitted a copy of the acquittal order. Then your lordship will see relevant paragraph after noting all this. Please, your lordship will see paragraph 10 onwards.
Yes.
His Lordship, see paragraph 11, this was a major factor which weighed with the High Court, while last 4 lines, Your Lordship, while there can be no doubt that the petitioner had failed to make the relevant disclosures in his online application form, it is undisputed that he had informed the respondent about his involvement in a criminal case and subsequent acquittal even before he had actually joined service. In the light of the fact that the petitioner did not disclose any information about his involvement in a criminal case in the online application form, there can be no doubt that strictly speaking, he could be said to be guilty of suppressing material information, and therefore the occasion arose for the respondent to consider whether action, if any, be taken against the petitioner in accordance with the instructions in the respondent advertisement and the undertaking submitted by the petitioner at the time of filling up. Then your lordship will see that instructions are being noted. And finally, at paragraph 13, the advertisement or the recruitment rules do not per se debar a candidate from applying for or getting appointed to the position in question merely because the candidate has at some earlier point of time been named as an accused in the FIR and who stand discharged in the case. Thus, non-disclosure of the registration of the FIR by the petitioner at the initial stage did not lead to the petitioner deriving any benefit which he would not have had he made disclosure. Moreover, the above extracts from the instructions of the advertisement dated so and so and the offer shows that making of a positive claim which is false is treated differently than the submission of an incorrect information which is found to be false. While the former is stated to result in cancellation of the candidature and termination, the later only states that action can be taken against the candidate, meaning thereby that action may or may not be taken. Even if taken, it may or may not be of an extreme nature, resulting in termination depending upon the nature or false or incorrect statement made by the candidate. This shows that termination need not necessarily be the result in every such case based only and only on the ground that there is suppression, falsity, incorrect statement made by the candidate. The question thus would be whether merely because the petitioner had failed to provide the requisite information in the first instance itself, his services could be terminated without even examining the relevant factors, including the nature of the offence, his subsequent acquittal, as also the fact that he had himself had furnished the said information prior to his joining service. Then your Lordship will see same Avatar Singh is being quoted.
Yes.
Yes. And final, your Lordship will see after paragraph 15. When we examine the impugn order of termination as also the minutes of the selection committee held on 31/1/2019, we find that none of the above factors have been considered and termination order has been directed to be passed by simply holding that since there was suppression of material information by the petitioner, his services ought to be terminated. In our view, it was incumbent upon the respondent to consider the petitioner case on the parameters laid down by the Supreme Court in Avatar Singh's case, which is not being done. As noted herein above, the petitioner had not only brought the relevant facts to the knowledge of the respondent even before his joining service, but he also stood acquitted of the offences levelled against him.
No, but in these cases, he stood acquitted, Ms. Lamba. In your case, I think that the case is still subsisting.
Mr. Lordship, in fact, that's the thing. In my case, they have not even cancelled my candidature on the suppression. This is what they've said in the counter affidavit. But if your Lordship will see their cancellation order, that's mainly on the ground.
But even the Supreme Court decision, I mean, it is after acquittal, correct? And even this, your Delhi High Court judgment,
compromised.
After acquittal.
It's compromised, well, 320.
After compromise, yes. And the other judgment?
Yes.
The others, short Supreme Court judgment, that also acquitted.
Yes, that was also based on acquittal.
Yes.
Yes.
He was acquitted on so and so. Right.
Cancellation.
But the thing is that
Please,
acquitted.
Yes.
So all these cases
Please,
won't
Lordship,
apply.
come back.
All they apply to your case because in your
Please,
case.
Lordship, would come back to Annexure R8 in the counter affidavit. This is the reason for cancellation. In fact, that's not even the reason. If your Lordship would come back to Annexure R8, please, your Lordship would find that at page 68 of their counter affidavit.
Annexure?
R8, page 68.
Page 16.
68. 68.
Just bring out IPC.
No, whose affidavit?
Please, Lordship, their counter affidavit. Their affidavit.
Doesn't have 68
Annexure
pages.
R8.
R8, okay.
Yes.
1 second. Page
68. Please, Your Lordship, this is the letter dated 8th of October 2024.
No, what? 68. This one is 68 pages here.
I'm sorry, Your Lordship, that's Annexure 8 of my petition. I'm sorry. 68.
Yes.
Yes. Please, Your Lordship, you see paragraph. This is a letter addressed to me informing me about the cancellation. Please, Your Lordship, would have paragraph 2. Multiple correspondences have been carried out with the Office of the Commissioner of Police, Hingoli, Maharashtra, Office of the Police, Hingoli, New Police, Vasahat, Hingoli, Shahar, Maharashtra, so and so, to a certain status of legal proceeding in respect of verification of character and antecedent as referred in the police clearance certificate deposited during recruitment proceedings. Verification of FIR lodged in respect of Sambhaji Suresh Thambore has been received from Office of Superintendent of Police, Hingoli, Maharashtra, wherein it has been intimated that FIR number 02414 is lodged against the individual under IPC section 353, 332, 504, 506.
Yeah, so what do you want to say by this?
Please, Roger, I want to say that their ground for cancellation is only that a criminal case is pending against me,
Right.
and not that I have suppressed any information. So all those relevant factors, that what was the nature of the case for which I had not disclosed in my online application form, and subsequent communication where I myself had disclosed about this, that has not been examined by them.
Yes, Dr. Mazika.
And first, I'll point out
And that is why your
the
lordship
application
has
level.
shown to your lordship on the last occasion
What do you-
before
this-
judgment, where the courts have held that merely because a criminal case is pending cannot be a ground for rejection of candidature, and a balance has to be brought in the sense that the appointment can be subject to a criminal outcome of criminal case, and whatever happens in the criminal case, I will abide to that. Because in any case, if I stand convicted in the criminal case, my appointment, if granted, would in any case be cancelled.
Yes.
Well, page 51 also kindly sees the application, my lord. There is not disclosed. Page 51 of the
They disclose it at a subsequent age. Stage.
subsequent stage, my lord.
51.
Page 51 is the application, my lord, online application.
Second. No, that's all right. 51.
It's serial number 18, my lord.
Yes.
Criminal proceedings details, if any, NA. So he didn't disclose, my lord. Subsequently discloses, and then that has been confirmed by the Superintendent of Police of Maharashtra, my lord. The criminal case is still pending. Now, my lord, can the department be bound to appoint such a person who has to face trial, my lord? If he is appointed in Manipur, my lord, on every date we have to grant him leave to go and face trial, my lord.
Where did you disclose it? When?
Please, your lordship would find that I had disclosed that when I had appeared before the medical examination. I'll
After
show
selection.
that
After selection.
no, before selection, before the final
Where is
result is
that?
declared. Yes, please, your lordship would find that is letter dated 17th April 2024, that your lordship would find at page 11 of their counter. Please, Your Lordship would have paragraph 2 of this letter.
Yes.
It is intimated that Shri Sambhaji Suresh Thombare, son of Shri Suresh Vaman Thombare, is a resident of village 80 Rajona, TQ Basma, Thingoli, district of the state of Maharashtra. Individual has attended Assam Rifles Technical and Tradesmen's Recruitment Rally 2023 against the vacancy allotted to Maharashtra state and submitted under mentioned documents FIR number 0214 dated 31st May 2022. Board of Officers has observed individual as a suspected case. Hence, it is requested to clarify that Sri Sambhaji Suresh Tambore, son of Sri so-and-so, can be enrolled in CAPS under the above charges as mentioned in the FIR number 0214 dated 31st May 2022. About reply on the above clarification may please be forwarded to this office in English language for a further necessary action, please. So before the declaration of result, I had appeared before this board and myself submitted copy of the FIR.
Yes.
And this is a letter which they have annexed with their counter.
From page 58 of the writ petition, what it appears, my lord, the final merit list is here, my lord, 18th August 23.
So he disclosed it during the stage of selection itself.
Yes. And then, Your Lordship, you see, my candidature has been cancelled way after on 8th of October 2024 with the letter which I had shown to Your Lordships at page 68.
Well, final list is at page 58, my lord. This is dated 18th August 23.
What is selection completed? Call letter.
Page 58, lots of kindly see, my lord. Where is the...
Yes. Where's his name? This is dated 18 August.
It is to be pointed out, I can't find it here. Can you see somebody's name? Let's see.
Please, Your Lordship, it is only after the result that I was called for medical examination and before this board, and that's when I had
results
it on April 2021. Because that was the only occasion for me to have appeared before the board once I was declared successful in the merit list. So when I came before the board, I myself disclosed this.
After selection, my lord, when reported for medical...
No, selection came only after I would have cleared medical examination. So that stage never occurred because they kept me as a suspected case, which Your Lordship has seen from that letter.
But our case is, my lord, somebody facing trial cannot be recruited, my lord. This is a discipline force and we would allow him leave to go on every date fixed in the criminal court, my lord, all the way to Maharashtra.
What are judgments she had placed with regard to...
I also placed one judgment, my lord.
Please, Your Lordship, I placed 4 judgments. Please, Your Lordship would have... there were 2 of Kerala High Court, one of which was even upheld by the Supreme Court, though by a dismissal in limine order, and there was one by Delhi High Court which had in fact dealt with this very question and said that you can balance it by making the appointment subject to pendency of the criminal case. Please, Your Lordship would have paragraph 4 of this judgment.
See, the nature of case also.
In case the petitioner is eventually convicted in that case, the respondent shall be free to terminate the services of the petitioner without the petitioner having any equity in his favor due to this order or his services rendered in the interim. We further clarify that the petitioner shall not be entitled for any service benefits for the service that is rendered by him in case of his conviction, except for the pay that is earned for that period.
But in Assam Rifle, you have to impart him training for 2 years, my lord. There's a lot of investment the department has to do.
You reading this Vikas Nagar?
This is also CISF of armed force.
Which judgment are you reading?
Please, Lordship, the Delhi High Court judgment, Vikas Nagar versus
Okay, which
Union of
paragraph?
India and others.
What is that?
Yes, please, Lordship, would first see paragraph number 1. This was for CISF, where also the person was declared, his candidature was cancelled because there was a criminal case pending against him.
What reason is it? They've not given a copy of something.
Please, Lordship, I'd given the copy last time.
There are only 3 decisions in this compilation. Only 3 in this.
No, this earlier one given on 4th of December.
Please, Lordship, would have paragraph 3 of this judgment. The petitioner cannot be made to suffer a punishment when the criminal case is yet to be adjudicated. We do not need to emphasize that in the matters of public employment, the opportunity does not come repeatedly and may never come for the petitioner again. The petitioner has been successful in obtaining the employment with the CISF based on his own merit and qualification. In case the petitioner is not allowed to join subject to the pendency of the criminal case, the petitioner may lose this opportunity for all times to come, and this loss would never be compensated. On the other hand, in case he is eventually found guilty, the balance can be struck by making his appointment subject to the outcome of the criminal case, and in that event directing that he would be terminated from service without any notice or following the rigors of an inquiry. And that is why, if your lordship will see in paragraph 4, the court has actually directed that in case the petitioner is eventually convicted in that case, the respondent shall be free to terminate the services of the petitioner without the petitioner having any equity in his favor due to this order or his service rendered in the interim. We further clarify that the petitioner shall not be entitled for any service benefits for the service that is rendered by him in case of his conviction, except for the pay that he has earned in that period. Then your lordship would have the next judgment of Kerala High Court. Please, your lordship would have paragraph 7. This is also on the similar lines. Denying appointment to a candidate selected for appointment by the Public Service Commission just because he was implicated in a criminal case, the result of which may either be conviction or acquittal, is certainly denial of his opportunity to enter in service when chances of getting employment is now a nightmare due to the risk of tough competition. If at last the victim is honorably acquitted, he will be languishing, losing his hard-earned chance of employment. If this is encouraged, naturally one who has enmity towards a person can destroy his future by implicating him in criminal case, as politically motivated gang atrocities are not rare and distinct. Such situation, the police in their FIR gives a vague report as so and so and 30 or 40 others. This others can be conveniently filled with any name according to the whims and fancies of the investigating officer. The victim in the present case may be one such person whose destiny is in the doldrums. Ultimately, after training, if he is found guilty, the petitioner can be dealt with as per law. Then your lordship would have next judgment of Kerala High Court. Again, please lordship, this is a very lengthy judgment. If your lordship would just come to paragraph 20, page 27 of this judgment. His lordship would have just where paragraph 9 starts, 3 lines above that. Thus, mere registration of the criminal case will not enable the government to disqualify such a person from becoming a member of the service. And this judgment, your lordship will see, has been upheld by the Supreme Court. Your lordship would have page 32. The SLP against this judgment was dismissed. No, I must bring to your lordship notice in paragraph 9, though of course the Supreme Court, paragraph 10, the Supreme Court has said the question of law raised by the learned counsel for the petitioner state is kept open for being considered in an appropriate case, but otherwise the SLP was dismissed. And please, your lordship will see that today the fate of this person of this FIR is of the year. Please, your lordship will see year 2022, and 4 years down the line, even the charges have not been framed. We are still at the stage of framing of charges. 4 years down the line. 31st May 2022 was when the FIR registered, and today we are in February 2026 and still at the stage of framing of charge. So as on date, there's not even a prima facie opinion by the court because the charges have not been framed, neither charges framed nor have been discharged. Since last more than a year, it is at the stage of framing of charge. And please, the lordship would also examine the merit of this person, that there was only 2 posts for the state of Maharashtra, which was subsequently increased to 10. So he was selected in only one of out of those 10 posts.
Yes, Dr.
Yes. Let's check. Have you said anything? Post filled up or not?
What about coming back to the advertisement? You see, if any information given by the applicant found to be false, that warrants, cancellation.
Yes, ma'am.
How do you reply to that? Because your case fine, it is just a case is pending that it will not operate as a bar. But the only thing is that he had to disclose it. He disclosed it at a later stage after the selection process was over. Correct?
No, lordship, according to my sanction, the selection process was still going on. Because I had first appeared, before the board only on 8th of October 2020.
No, fine. But the thing is that now we have to go by the advertisement. Correct? Whatever rights you have, whatever it is, the advertisement has to be looked at. Now, whether the advertisement prohibits, has answered such condition that if it's false, then they're within their rights to cancel your appointment. Where's 28? How do you answer this clause 28? Yes. It's been given subsequently, correct? 28 of the advertisement.
Advertisement itself says, my lord, page 42.
Our petition?
Yes, ma'am.
Yes, you see that.
Serial number 27, 28. Rejection of application in case the information furnished by the candidate is not read also properly.
In page 41?
Yes, ma'am.
28 is not here.
Page 42, ma'am.
No, there's a clear copy here. Use the same.
In case of information furnished to the candidate in application for found to be false at any stage of the recruitment rally, and even at a later stage, the candidate shall be summarily rejected without any notice. Appropriate action will also be taken against such candidate as per the provision of law by registering FIR with the police. So, my lord, there are 2 aspects, my lord. One is the factum of pendency of criminal case, and second aspect is the non-disclosure or suppression of this vital fact, my lord.
It was disclosed in the detailed medical examination.
My lord. Now, my lord, I placed a decision of Supreme Court, my lord, and that was a full bench decision, my lord. 3 judges.
Avtar Singh. Please, the lordship will see that has been in fact been considered by the Supreme Court also subsequently in the judgment which I had shown to your lordships.
Can I just place it first?
Please, lordship, on the aspect of non-disclosure, I simply just say one
That's
thing.
the only thing, yes.
Now, not concluded. Let me conclude it.
Yes, have you concluded, Ms. Lamba? Yes.
Yes, Your Lordship, just one thing and then I've concluded.
Yes.
That for on the aspect of non-disclosure, like as the judgments have said that you cannot simply because somebody is disclosed may not be the correct approach, and you have to examine all the relevant factors including the socio-economic background, the age of the person, and if the person has subsequently disclosed, and if yes, at what stage. So in my opinion, in my submission, none of these factors have been considered, because as Your Lordship has seen, the cancellation was only on the ground of pendency of a criminal case and not on the ground of non-disclosure. So these factors have not been examined by the committee today. That's all, Your Lordship. Not concluded.
Para 38 is the conclusion of the judgment, Madam Avtar Singh. The law has been summed up by 3 judges. Read on para 38 onwards. We have noticed various decisions and tried to explain and reconcile them as far as possible. In view of the approach discussed, we summarize our conclusion thus. Information given to the employer by a candidate as to conviction, acquittal or arrest or pendency of a criminal case, whether before or after the entry into service, must be true and there should be no suppression or false mention of required information. While passing order of termination of service or cancellation of candidature for giving false information, the employer may take notice of the special circumstances of the case, if any, while giving such information. The employer shall take into consideration the government orders, instructions, so and so. In case where there is suppression or false information of involvement in a criminal case, where conviction or acquittal already been recorded before filing of the application verification form, and such fact later comes to knowledge of the employer, any of the following recourses appropriate to the case may be adopted. In a case trivial nature, this we can skip, my lord. 38.5 is important, my lord. In a case where employer has made declaration truthfully of a concluded criminal case, the employer still has the right to consider antecedents and cannot be compelled to appoint the candidate. In case where when fact has been truthfully declared in character verification from regarding pendency of a criminal case of trivial nature, employer in facts and circumstances of the case in his discretion may appoint the candidate subject to decision of such case were declared, my lord. In a case of deliberate suppression of fact with respect to multiple pending cases, such false information by itself will assume significance, and an employer may pass appropriate order cancelling candidature or terminating service on appointment.
Do you have any written policy with regard to verification of character certificate verification? Now, some rifles, because the impugn order says that a proposed candidatures have been cancelled due to policies in respect of character certificate verification.
Yes. Yes, Your Lordship, there is a reference to a policy of, please, Your Lordship, just 1 second, 31st May 2022, which they have not.
Whether there is a specific policy or not, I'll require instruction, but the advertisement